man.
The court order says that you must take steps to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution.
Gentleman's
and you
time
should
has
fight
expired.
for due process. Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that notwithstanding your statements under oath here today that Mr. Kilmar Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence... So you're not going to commit to follow this order? You won't commit to follow this court order?
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering. Stop filibustering.
By gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately, sir, and he is not.
How can you say he's been treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately? Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
no.
is investigators and law enforcement officers.
That is you making that determination.
The case they built against him. If you don't trust our law enforcement
officers, the court has considered all that. The judge has considered all that, Madam Secretary. And if you would be quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What
If he were to come
steps
back here,
have
your
you
advocacy-
taken?
If your continued advocacy for him were to...
I'm not advocating for him.
Yes, you
I'm
are.
advocating for a
Absolutely.
court order, Madam
Gone to the
Secretary.
mat for this
The
man
court
who
order
has terrorized
says
people
that
in
you
traffic
must take
with human
steps
beings.
to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution.
The gentleman's
and you
time
should
has
fight too for
expired.
due process.
The gentleman's time has expired. I now recognize.
What made that Goldman-Noem exchange so explosive wasn't the volume, it was the stakes. Strip away the theatrics, and you're left with a blunt question. Do we live under a system of laws where courts have the final say on rights and remedies, or under a system of assertions where the executive's label, gang member, terrorist, dangerous, can erase process after the fact? Goldman started by anchoring the basics. Congress writes laws, the executive enforces them, and the judiciary interprets them and orders remedies when rights are violated. That wasn't a pop quiz. It set up the central tension. In the case at issue, the courts, culminating per Goldman's framing in a unanimous Supreme Court ruling, found that Kilmar Abrego Garcia had not been afforded due process and that an existing order withholding his removal barred deportation until that order was properly terminated. That's a critical legal point most people never hear explained. Withholding of removal isn't a discretionary favor, it's a statutory protection. If an immigration judge has entered that order, the government cannot lawfully deport the person to that specific country unless and until the order is lifted in a proceeding with notice, evidence, and an opportunity to contest. You don't cure the violation by insisting you knew he was removable. You cure it by going back to court and proving it. Noem's responses tried to substitute accusation for adjudication. Law enforcement said he's MS-13. The department says he's dangerous. End of story. But in our system, allegations, no matter how serious, aren't a substitute for process. That's the entire point of due process. The government bears the burden to prove its claims in the proper forum. If the evidence is truly strong, it will hold up when the government petitions to terminate the withholding order. If it won't, then the state doesn't get to skip the rules by branding someone with a label and moving them out of reach. Goldman also pushed on a second layer most viewers might miss. Compliance isn't passive. When a court says a removal violated an order or that due process was denied, agencies don't get credit for shrugging and saying, well, he's already gone. Courts routinely expect facilitation in the active sense, coordinating travel, issuing transportation letters, using parole authority to permit reentry, liaising with foreign and state counterparts, and, crucially, joining or not opposing motions to reopen so the underlying legal questions can be heard the right way. That's not advocacy for the individual. That's obedience to a remedy designed to put the parties back in the position they would have been in had the government followed the law the first time. Noem's deflection, suggesting that insisting on due process equates to fighting for a terrorist, is a tell. It's an attempt to make the rights debate about the person's character instead of the government's obligations. But our constitutional architecture was built specifically to withstand that temptation. The unpopular, the feared, the accused still get procedures. Because once we normalize cutting corners for them, those shortcuts become the path for everyone else. Today, it's a man accused of gang affiliation. Tomorrow, it's a dissident, a journalist, or simply someone who got caught in a paperwork error. In immigration law, those errors can be life-altering: a missed notice, a misfiled form, a mistranslation. That is precisely why the judiciary's role is non-negotiable. There's a deeper institutional risk in Noem's stance, too. When executive officials signal that court orders are optional, they don't just weaken one case, they corrode separation of powers. Agencies depend on judicial legitimacy to defend their lawful actions tomorrow. If they undermine that legitimacy today by disregarding adverse rulings, they're sawing off the branch they're sitting on. That's why Goldman's insistence on concrete steps, what exactly has DHS done to comply, matters. It's not theater, it's oversight. One more nuance often lost in the noise: even if an organization is widely reviled, the legal categories that trigger different consequences are precise. Immigration law has specific grounds of removability, bars to relief, evidentiary standards, and burdens of proof. Whether a person fits those categories is decided in proceedings, not press conferences. Calling someone dangerous doesn't collapse those distinctions. It heightens the responsibility to meet them. So what should viewers take from this? First, due process isn't a courtesy. It's the operating system. Second, courts don't merely offer opinions. They issue orders that bind agencies, even when politically inconvenient. Third, constitutional government is tested not by how it treats the innocent and beloved, but by how it restrains itself when dealing with the accused and despised. If leaders can wave away rights by invoking fear, the rights were never real. If you value rule of law over rule by assertion, stay with us. We break down these flashpoint moments so you come away with more than a headline. You come away with the tools to spot when power is overreaching and what accountability looks like in practice. Subscribe, share this analysis with someone who thinks due process is just rhetoric, and come back for the next deep dive. Democracy only works if enough of us insist it does.